Hi everyone and welcome back. So today we are going to discuss a very important and often confused concept in the topic of intellectual property rights, that is geographical indications versus trademarks under the Indian law. Now, if you are a law student, a content creator, a business owner, or even someone who's interested in branding, this topic is something that's extremely relevant because both GI and trademark deal with the identity. It's just that they both protect different types of identity. So today we will break down the simple, practical, and in a legally accurate way. So let's begin with trademarks. Now, under the Trademarks Act 1999, a trademark is a sign that is capable of distinguishing the goods or services of one person from those of others. So now what does it exactly mean? In simple terms, a trademark is your brand identity. It may be a name, it may be a logo, it may be a symbol, a tagline, even a sound in some cases. For example, uh, Nike with a swoosh logo, Amul, the name itself, Tata. Now, these marks, they help the consumers to identify the source of goods. So when you see Amul butter, you immediately associate it with a particular company and quality. The key idea here is that your trademark is your source identifier. It tells you who is behind the product. Now, let's quickly understand the features of a trademark. Firstly, it is owned by an individual or a company. Second, it gives exclusive rights to use the mark. Third, it can be licensed, assigned, or sold. Fourth, it has a territorial protection, meaning the protection is limited to the country where it is registered. And lastly, the trademark can be renewed indefinitely as long as they are in use. For example, if a company registers a brand name for clothing, no other company can use a confusingly similar name in that category. Now, let's move on to geographical indications, or what is commonly known as GIs. In India, GIs are governed by the Geographical Indication of Goods, that is your Registration and Protection Act 1999. A geographical indication is a sign used on products that have specific geographical origin, and they also possess certain uh, qualities, reputation, or characteristics that are essentially attributable to a particular location. Now, let me simplify this for you. A GI tells you that this particular product, it comes from a certain place and its quality is linked to that place. Some classic examples are your Darjeeling Tea, your Kanchipuram Silk Sarees, your Alfonso mangoes, your Kolhapuri chappals. What else is common in these? Now, their uniqueness is something that comes from the soil, the climate, the traditional knowledge, the skill of local artisans. Now, the key idea here is that GI is equal to origin plus reputation. So let's further understand what exactly are the features of GI. Now, firstly, GI is not something unlike copyright, trademark, or patent, which is owned by a certain person. It is collectively owned by the producers, the associations, and the communities. Second, it can neither be sold or assigned like a trademark. Third, it protects the traditional knowledge and cultural heritage. Fourth, it only authorizes only the authorized users can use the GI. Fifth, the product must maintain its quality standards linked to the geography. Now, for example, only tea grown in Darjeeling can be called as Darjeeling tea. Anyone else using that name is clearly committing an infringement. So let's understand what exactly is the difference between a GI and a trademark. And let us break it down in a very conceptual way. So first, let's talk about the ownership. In case of trademark, it is owned by an individual or a company. In case of GI, it is collectively owned by a community or an association. Second is the purpose. The idea behind a trademark is that it identifies the source of a good. With GI, it identifies the geographical origin of that particular good. Third is the transferability. Now, your trademark, it can be sold, licensed, or assigned. Your GI, it cannot be transferred. Fourth is the nature of rights. Your trademark gives you private right. Your GI gives you community right. Fifth is the comparison. Let's take, for example, your Taj Mahal. It is a trademark. Okay, everybody knows. We know Zakir Hussain, we know Taj Mahal tree, etc. But when you talk about Darjeeling tea, it is a GI. It tells you where the tea came from. So one tells you about the brand, the other tells you about the origin. Sixth is your protection objective. Now, when you are registering a trademark, your objective is to prevent the consumer confusion. But when you are registering a GI, it definitely prevents misuse of regional reputation. Now, let's talk about the practical overlap which usually happens. This is a very interesting point. Sometimes a product can have GI as well as trademark elements. For example, a company which sells Darjeeling tea may have a GI tag for the origin, a trademark tag for the brand name, and both systems can coexist. So if I were to summarize this, the trademark, it protects the business identity, and the GI, it protects the geographical identity. A trademark is about who made it. A GI is about where it comes from. And both are very crucial in today's economy because one helps in branding and marketing, and the other, it helps in preserving the heritage and boosting local economies. And as legal professionals, it is very important that you understand this distinction, especially in sectors like agriculture, handicraft, fashion, and food industries. Thank you so much, and do keep on following me for more such interesting content on IP law media and startup. If you found this helpful, do share it with your friends and fellow law students, and let me know in the comments which GI product from India is your personal favorite. And I'll see you in the next session. Thank you so much.